For coming. My name is Peter Bang. I'm one of the 1L representatives with the Asian Law Students Association. And before we begin today, I just want to first thank the program in public law for co-sponsoring this event with us, and also Dean Jennifer Marr for putting us in contact with her brother-in-law, Mr. Dunne. Also, I do want to let all you guys know that this lecture is being recorded, so please no singing in the middle of the lecture. And now I have the honor of introducing Mr. John R. Dunne. He, from 1966 and for 23 years, Mr. Dunne served as a senator for the New York State Senate, where he was the deputy majority leader and the chairman or the ranking member of 6 different committees. He was reelected 11 times. From 1990 to 1993, he served as the Assistant Attorney General to the Department of Justice, Civil Rights Division, where he oversaw the U.S. government's formal apology and redress to the Japanese Americans forced in internment camps during the Second World War. And since 1994, he's been a senior counsel to a law firm in Albany, New York, named Whiteman Osterman Hanna, where he remains today. He is a graduate of Georgetown University and Yale Law School. And without further ado, please welcome Mr. Dunne.
Thank you, Peter. It's good to be back here at Duke Law School. I was here in 1990 when you invited me to come and speak about some of the work of the Justice Department, where I was privileged to serve under Attorney General Dick Thornburgh and the first President Bush, the good one. And it was a great experience for someone who's been at the bar as long as I have. In fact, on Friday, I will be celebrating my 58 years as a member of the New York State Bar. Yes, I do get up every morning, take nourishment, and think about the problems that I considered when I was like you in law school. And throughout my career, I've been privileged to discuss. Until the room fills, I thought I might just tell you about some of my experience. Yes, it was about 58 years ago. I finished Yale Law School. I thought I was headed for Wall Street, be a big corporation lawyer, and I wound up at Milbank Tweed in the litigation department, and it was a great experience, and terrific training, as you would expect from one of the old prestigious firms. And it wasn't too long before I realized that either Wall Street wasn't for me or I wasn't for Wall Street. And I always harbored the hope of getting into politics and running for elective office. In fact, that's the principal reason why I decided at the age of 8 to become a lawyer. And I can tell you that in 75 years, I have not looked back or questioned that juvenile decision, which has provided a very rich life and a wonderful and very fulfilling professional experience. When I was in I have served in all 3 branches of government, judicial, legislative, and executive, at all 3 levels of government, county, state, and national. It's given me a good opportunity to reflect on the role of law and the proper role of government. And during that period, while I was in government, I always maintained a private practice. I wanted to live the law as well as make it, interpret, and enforce it, but I wanted to be an actual living, practicing lawyer, which I feel has been very advantageous to me. During the course of that experience, I've encountered a number of problems, whether you want to call them ethical or professional. When I chaired the Senate Committee on Prisons, I was invited by the prisoners at Attica Prison in the midst of their riot in 1971 to come and attempt to mediate between the administration and the prisoners. And that was due to the fact that I had spent 4 or 5 years, I like to think, championing or pressing for prison reform, measures which I found were not a priority with my colleagues or, unfortunately, with the state of New York. That was good training. I was there with some leading civil rights advocates, and we were working to try to avoid the horrendous result of the troopers and the National Guard moving in and with firepower and tear gas, which resulted in the killing of 41 of the people out there in that yard, among the rioters as well as the guards. I also had the experience of working on the issue of capital defense. After I was unceremoniously sent home from the Justice Department, some of you may recall that Bush 1 served only one term, and those of us who were his appointees were told to go home as well. And I joined up with a group of my friends in Albany, practiced law, and also shortly thereafter I was appointed as a member of what had been established by statute as the Capital Defender Office of New York. Some of you historians may recall that in 1945, New York by statute restored the death penalty to New York, something that we weren't particularly, some of us were not particularly pleased with, but it also provided in that for the creation of the Office of Capital Defender, composed of 3 lawyers appointed by the Chief Judge, by the Majority Leader of the Senate, and the Speaker of the Assembly, to set up an office to provide defense for indigents charged with capital crime. We set about our job, the 3 of us, having differing views with regard to the propriety of capital punishment, decided when we met that we would put politics aside, and what we would do is try to fulfill what the legislature expected from us, and that is to establish the best darn law firm to defend those who were indigent and could not adequately defend themselves against the ultimate penalty. I'm happy to report that we were lucky enough to attract some of the greatest talent from around the country, and I think the best evidence of that is that we were successful in convincing our state's highest court. Mind you, it was only a 4-3 decision, but 4-3 is better than 3-4. And we got the court to declare the statute unconstitutional. There is very little support today for reestablishing that penalty, but I got to tell you, I fear every day that I'm going to pick up the paper and find that some individual has murdered 3 members of the New York City Police Department, and that could stir up the embers of hate and revenge, which we have so far been able to successfully overcome. I would just say to you, first, I wish I were out there and were listening to somebody else, because I envy you with regard to the opportunities that stand before you. My one thought would be, because I think it's been successful for me, is always remember you're a lawyer. What a privilege it really is. Not only intellectually, but also it gives you an opportunity to have a window on the communities either from which you came or where you currently serve. You're working with people, you're working with crucial issues, you are provided with a certain amount of independence in your life because you have a license or profession which cannot be taken away from you unless it's your fault. And it's really a wonderful, privileged opportunity. There are side benefits. Being in politics where you don't know where you're going to be attacked from, it gives you a certain amount of independence that if certain people are not pleased with your action or what you've done in your public role, you have the independence to know, I'll try to do the best I can. I'm going to make some mistakes, but if you think I'm not suited for it, I'll go back to practicing law. It's always provided a certain amount of comfort and confidence. In addition, as my wife and I agree, I made enough money to straighten 4 sets of teeth to our children. At least they are, aren't they? And to find a position in the community. The other point, and I would urge this very strongly, be active in the profession. How do you get active in the profession? Join the local bar association. I became the youngest president in the history of the county bar association where I came from. I was a member of the House of Delegates of the New York Bar and a member of the House Delegates of the American Bar Association. I wrote for law journals as well as popular magazines on subjects of interest to the public. And that way, you develop not only a professional persona, but you get a sense give a sense in the community that you are someone who is a leader, who's thinking about people's problems and trying to find some solutions. And so I would urge you to keep that in mind as you go forward, as I know all of you after Barbary and the other cram courses will stand you in great stead. I'm particularly grateful to the Asian law students for inviting me here, because when I became the Assistant Attorney General for Civil Rights, principally because of a long-time friendship I had with Dick Thornburgh, who was the Attorney General of the United States, appointed first by Reagan and then by Bush. He recommended me to the President for appointment, and among the issues which I immediately had to address in 1989 was the study which had been made and the legislation which followed, a very strong report with regard to the relocation of Japanese Americans following the attack on Pearl Harbor in 1941. And so I thank you for setting up this forum today to discuss the impact of what was perhaps one of the darkest moments. That was when President Roosevelt issued Executive Order 9066, which provided for the removal from their homes and incarceration in detention centers of approximately 125 Japanese Americans solely because of their heritage. No other reason given for it. And I hate to admit it, but I'd say that it's probably one of the darkest periods in American history, if not the darkest items in American history. And I would hope that as a result of the lesson we learned and the response we made, we will renew our commitment to justice in the future. We now know that a long history of prejudice and hostility toward the ethnic Japanese preceded the evacuation, relocation, and internment, and that the bombing of Pearl Harbor stirred the embers of racial prejudice. In that time of national hysteria, we lost sight of one of our nation's ideals, the passionate desire for freedom, the ideal which our nation was founded on, and the true principle for which we really fought the Second World War. It required strength and faith for the Japanese Americans to persevere and to preserve their dignity during the hardships of the internment. These same characteristics gave them the strength to endure their long journey toward justice and redress, which I'm happy to have an opportunity to talk with you this morning. Just who were these Japanese Americans? Let me tell you, I have a little something here that tells you a little something about them. I said there were approximately 120,000 in the states of Washington, Oregon, and California. A little bit of Arizona, but that's about it. There were 1/3 who were aliens, admitted properly to the United States, but 1/3 of them aliens who had been born in Japan. They were the Issei. The next category in Japanese was the Nisei. They were the men and women who were born in the United States of Japanese parentage, and they numbered about 2/3 of the 120,000 plus. And the third category are the Issei, which I will talk about later, and they were the children of the Nisei, and so really third generation of Americans, Japanese Americans, that we will be talking about. How did we get to this situation where amid war hysteria, that there was this broad support, not just by the President and the Congress and later by the Supreme Court, but there was broad support for taking these people out of our community because they posed such a threat. This is not by way of apology, but to understand the national mood. In December of 1941, after the Pearl Harbor attack. The Japanese armies attacked the Malay Peninsula, Hong Kong, Wake and Midway Islands, the Philippines, Thailand, Guam, and successfully defeated our Navy at the Battle of Coral Sea. And I can remember as a child growing up at that time in my early teens, people in America were really scared. They were frightened what happened, not only by the impact of the December events, but also the very bad news we were getting during 1942 and 1943 as to the defeats which we had been handed. And so there was this war hysteria. An example, Californian congressman, quote, "All Japanese, whether citizens or not, should be placed inland in concentration camps." Westbrook Pegler, one of the most popular syndicated columnists, "Japanese Americans should be placed under armed guard to the last man and woman right now, and to hell with habeas corpus until the danger is over." Even a person as responsible as John J. McCloy, who was the Assistant Secretary of War, didn't have the Pentagon then, but Secretary of War, and who became the High Commissioner of Germany after the war and then became the chairman of the Chase Manhattan Bank, said, "Internment is retribution for Pearl Harbor." And initially, Attorney General Biddle and the Secretary of War, Henry Stimson, although they believed there was no reason for mass evacuations as a military measure, because in their thoughts early on, it would tear a tremendous hole in our constitutional system. While there was no evidence of any type of espionage or sabotage, the overbearing position taken by the general who was in charge of military affairs on the West Coast convinced those who were reluctant to go that route that they should impose what became a serious blot on our proud escutcheon. The internment of these Japanese Americans, based solely on their national origin, came as one of the darkest moments in our history. It left families divided and desolate. It carved a deep emotional scar which was passed on for generation to generation and fostered the anger and confusion that comes when one's own government so quickly and thoughtlessly deprives its citizens of public civil liberties. Well, now that we know a little bit about just the background on that, let me talk to you just who were these Japanese Americans in 1941. There were 126,000 in the United States. 2/3 of them, Nisei, were citizens born in the United States. 112 of those 126 resided in California, Oregon, and Washington, and parts of Arizona. 70% of them lived in California. I mentioned the Issei, who were the aliens, Nisei, Sansei, second generation, and Nikkei, which is the general comprehensive reference to them. Interesting, because of discrimination against them in terms of gaining a likelihood, 45% of those who were evacuated were engaged in farming. It's really interesting. They were mostly engaged in truck farming. Any of you from New Jersey know what a truck farm is? Well, that's a farm that's very specialized and plants a variety of crops, which they know there's an immediate market for in the local region. And it was interesting. They were so successful at this that the value of their land when they went off to relocation camps, nationally land was valued for farmland $40 an acre. Because of the successful use of their own land, the Japanese went for $280 an acre, 7 times. And this was due to the fact that they really understood their markets, they worked hard, and they were very successful at that. The total value of their land was $72 million. So we were talking about a very industrious, very hardworking, and committed citizens of the United States. I would have to divert, and this I'll talk about the question of loyalty. Are we aware that in 1943, 18,000 young Japanese American men volunteered to serve in the United States Army and became part of the famous 442nd Regimental Battalion. And they served with such honor that it was the most decorated unit in the entire United States Army. One of the sad footnotes was that even when they were on leave and their families were in relocation camps, they would not be permitted to visit them. They could, which was certainly just one more insult which was imposed upon these folks. Think about it. The most decorated combat unit in the entire United States Army were composed totally of Japanese Americans. Now, where was the real problem here? Well, caught up in war hysteria, President Roosevelt issued Order 9066 in February, and justified it because it was termed to be in protection against espionage and against sabotage to our national defense. The order provided that the right of any person to enter, remain, or leave a designated area to be identified by the military shall be subject to whatever restrictions the military commander may impose in his discretion. Now, the president appointed a fellow named J.L. DeWitt, who was a major general, and he was the military commander for the Western Defense Command. And on March 2nd, he issued a proclamation that no Japanese American can enter or leave certain areas without executing and delivering to the authorities a change of residence, which was very difficult to obtain. 2 weeks later, he issued an order, the War Relocation Authority, and because he knew that he would have no law enforcement means to apprehend those who had violated his orders, the Congress was convinced that they should support the general, and they provided that it would be a crime for Japanese Americans to enter, remain, or leave contrary to any restrictions. And later on, a number of orders provided not only to prevent their leaving the area, but also finally, on May 3rd, order number 34 provided for civilian exclusion. It excluded from areas and a family member must report to a civil control station for instructions to go to an assembly center, and the purpose was stated quite clearly to drive all citizens of Japanese ancestry into these assembly centers, which then led to their being taken to the detention facilities in 12 different camps located around the country. Now, General DeWitt justified his issuing that order. He said, because I've had reports that there have been signals from the shore to Japanese submarines and Japanese submarines back. There was no evidence of that whatsoever. The second was that these people are hiding arms and all kinds of contraband. The FBI conducted a search of hundreds of homes, found no evidence whatsoever. But the real reason he did this was his attack on the Japanese Americans for their dual citizenship, sending their kids to Japanese language schools. Can you imagine what happened to a Catholic kid or parent for sending their child to parochial school? I suppose that might be viewed as disloyal. And there were so many of them concentrated in one area, they must pose a danger. But if you understand his thinking and the study which was made after the war with regard to why did he do this, he was quoted in 1942 as saying the Japanese race is an enemy race. Their racial strains are undiluted by citizenship. We must worry about the Japanese all the time until he is wiped off the map. In the following year, If they are allowed to come back, when there was talk about releasing certain nuns from the camps, espionage and sabotage will follow. And in his wonderful style, he summed up his view by saying at a press conference, "A jab is a jab," end of story. But that, I cite the most unpleasant matters only because I wanted to understand really what was going on in 1942. Nothing that any of us could be proud of, but that's the way it was. And we have to be, if you don't mind my saying it, we have to be alert to that sort of government activity with regard to some others who today we are questioning as to their loyalty and what their intentions are with regard to the safety of our country. It gives us pause, and maybe if nothing else comes out of this discussion this morning, it might be that we must be alert to these problems. Now, the orders that were issued over the course of from February until June required every Japanese American to register, go to an assembly facility, and then be sent off to an internment camp. No charges, no charges. They weren't charged. They weren't charged with misconduct, or they weren't charged money. Well, let's hope. But that's another story I might get into in Hawaii. They were sent there to facilities which were just overnight constructed, and you can imagine the quality of the construction. But they were allowed to take one suitcase of their possessions with them, and that was it. Families were divided. The accommodations in these internment camps were meager at best, and they had little or no opportunity to question why they were there. But some did try. There was Fred Hirabashi, who was a resident of Washington, and he refused one of the orders, namely that all Japanese Americans should be in their homes at 6 o'clock at night and not show up until 8 o'clock the next morning, the Curfew Law. There was a subsequent law enacted when a voluntary relocation, which had been urged upon Japanese Americans, was proven unsuccessful, and they then issued the order requiring this registration going to internment. Hirabashi had violated both the curfew intentionally, admitted it in court, and he also refused to leave his home in Seattle, Washington. He was indicted, charged with both misdemeanors, and was convicted, and he was sentenced on each of the counts to 90 days to run concurrently. He appealed his conviction to the Circuit Court of Appeals in the Ninth Circuit. Ninth Circuit guys, I guess you could say guys because there weren't any women on the panel, said, hey, this is too hot for us to handle. We're going to certify this question to the Supreme Court and see what they say about it. Well, the case was argued in February of 1943. The claim by Hirabashi was that this was a unconstitutional order because there was no evidence of military necessity in order for the military to issue this restrictive order. The Supreme Court, by 9-0 decision, upheld the order, held that it was not constitutional because they repeatedly stated, and mind you, in 17 different points in their decision, they cited, we're not going to challenge the military's judgment as to what constitutes a threat of sabotage or subversion, we're not going to question that, and therefore we think we will not upset this order by the military. They dodged the issue on the relocation. He was charged with failing to observe the curfew and also the relocation of putting him in an internment camp. The court said, well, we've decided that to impose a curfew is a reasonable response, keep these people in their homes at night, and it's not that much of a burden on their liberty. So that's passed constitutional muster in our judgment. But since Mr. Hirabashi got a 90-day sentence on both to run concurrent, and he had served the 9 on the curfew, so we're not even going to discuss the issue of whether or not the relocation was justified. That issue came back once again in 1945 when Fred Karamatsu brought an appeal from his conviction for having failed to relocate in compliance with the military order. There, the court divided 6-3, with 3 very strong dissents from Justices Roberts, not the present Roberts, but a different Robert, Owen Roberts, Justice Jackson, and Justice Murphy. They dissented on the grounds that really there was no evidence of military necessity. The court should have looked at that issue. It did not, and therefore they dissented, but the 6 in the court said yes. It's interesting, if you go forward, having been involved in civil rights issues, as you know today, courts are taking a very strict view with regard to any set of circumstances where one's individual constitutional rights have been invaded. And the standard with regard to determining the propriety of such restrictions is that we will make a strict scrutiny of not only the events leading up to such an order, but scrutinize what has been the supposed remedy. And it must be narrowly tailored in order to justify the imposition of this restriction. We've run through that in a lot of civil rights cases, a lot of labor and employment issues. And so it's the judgment of virtually anybody in this field that had the court in 45 done what courts later on did in the 80s and 90s. These orders could not have stood because there was, on analysis, no evidence of any justification for a military imposition. It really came out in a study which was subsequently made by the Commission on Redress that indeed General DeWitt was a racist and that he justified his actions solely on the basis of racial considerations which had no place in regard to a decision made by a military leader. Fast forward, now mind you, that was 1945. After Hirabayashi had been released from the internment, in 1983 he sought to vacate his conviction, to clear his name. The trial court denied that relief because, in their judgment, curfew was relatively mild restriction, narrowly tailored to meet the problem. But in the appeals court, the court, mind you, actually said this, that General DeWitt was a racist and his military orders were based upon racist rather than military necessity. And that led, among others, to the Japanese American community getting together to try to do something to correct the injustice which had been visited upon them back in the 1940s. How did it happen? Well, there was a new generation of Japanese Americans, the sensei, that is, children of natural-born Japanese, the Nisei, who perhaps they were the products of the 60s and 70s, questioning authority, determining that they had every right to try to clear their name because of their heritage, and they banded together and provided the leadership for the older folks who really were committed to the Japanese tradition of, I get the correct pronunciation, gaman, G-A-M-A-N, which is keep it inside. Don't go public. If you have strong feelings, you keep it inside. But these youngsters decided that it was time to clear the name of Japanese Americans, and working together with a number of different organizations, principally Japanese American community organizations, was quite successful. Those were the Japanese American Citizens League, the National Coalition for Redress and Reparations, and the National Council for Japanese American Redress. This was a grassroots effort. The young people goaded the Nisei to get involved, and the response was enormous. They lobbied the Congress. They wanted some recognition of what had gone wrong, and they were successful in convincing President Jimmy Carter in 1980 to set up a commission to study the wartime location and internment. They studied this for a year and a half. They held 27 hearings around the country. They interviewed hundreds of those who had been interned, and they came out with a report which laid out the facts, and indeed there had been no legitimate basis for the internment as we had carried it out. The commission concluded that, as I mentioned before, signaling of ship to shore, no evidence. Naval intelligence had told DeWitt that there was no evidence. He plowed on anyway. The claim of arms contraband, the FBI study found no dangerous persons or dangerous weapons. To show his softness of heart, DeWitt said, well, now we're doing this for protection of the Japanese Americans against vigilantes. Hey, we can take care of ourselves, don't worry about it. And of course, there was no evidence of that type of an organization. And the dual nationality in Japanese language schools and a high percent of aliens in the population, really, there was no basis for that. This commission, which was composed of 9 people, came out with a very, very detailed report and debunked the evidence of the DeWitt position that ethnicity determined loyalty. FBI and naval intelligence, there was nothing more than careful watching of suspicious individuals to be required in order to avoid any kind of subversion. They concluded that General DeWitt had relied on civilian politicians that informed military judgments. There was no effective measure taken by FDR to calm the fears of the public. Remember when he was inaugurated in 1933? We have nothing to fear but fear itself. Unfortunately, I guess he forgot that, but he didn't provide the kind of leadership that some thought he should. The general exaggerated the needs for security over the liberty of citizens. The Secretary of War failed to insist on clear military justification. The Attorney General did not urge the President to make out a case against military necessity. Civil rights advocates were silent. There was no effective opposition, and the President, even making such a critical decision, such as the internment, consulted with no one in his cabinet and only a few close advisors. What was the result of that commission? After their strong findings, they determined that there ought to be some redress. There ought to be not only a monetary redress, but there should be a clear acknowledgement of wrong and an apology to the Japanese American community. And in our study, we found out in interviewing recipients, the apology was far more important than the $20,000. Just an aside, one of the folks out in the field interviewing some of the prospective recipients encountered a woman of advanced years, and she was, why didn't I get my check? And the answer was, well, we haven't authorized any checks yet. Well, I think my kids must have gotten my check because they've furnished their home and they're going on trips and that sort of thing. No, hold on, lady. That wasn't the case. But little asides like that. But the response was really very interesting. You had this damning report But what are you going to do with it? It required action by the Congress if indeed there's going to be any kind of any redress payments. And so these community organizations, they went to Washington, mind you, the West Coast. They went to Washington on their own dime, and they buttonholed members of the Congress. They talked to other officials in the various departments that had been related to this issue, and they wound up successfully convincing them that of the legitimacy of their cause. Immediately, the majority leader of the House introduced a bill which would provide the relief recommended by the Commission. It didn't go anyplace the first year. Second year, one of the houses had a hearing on the issue, but it didn't get to the floor. And finally, in 1987, with a big push by organized lobbying and letter writing, the House of Representatives in April of '87 passed the legislation providing for redress payments and the establishment of an education fund, and hopefully to avoid repeat. And later that year, in October, the Senate passed a bill. They reconciled the differences, and the bill was finally passed in October of 1987 when President Reagan was in office. The next problem was, will President Reagan sign this bill? You know, he had a big Japanese-American constituency in California where he came from, but he also had an awful lot of constituents who weren't too happy about this giving redress payments to Japanese Americans. Well, he signed the bill, and of course everybody was happy. It's the law, it's going to happen. But here was the problem. You know, when that ad, "Show me the money," when he proposed his next budget, he called for only $20 million to be given, and that would have paid 1,000 former internees. And for his budget in 1990, he provided no money whatsoever. And so there was, again, the challenge for the Japanese American community to come to the fore and attempt to achieve the justice which had been so long denied to them. However, the law did provide that it fell to the Department of Justice, and thus the Civil Rights Division, to carry out the redress program. And among the other interesting aspects of it, it specifically provided that the government must go out into the community and identify those who were entitled to receive. It didn't pose any burden upon the Japanese American internees to come forward. It was our responsibility to go out and find them. Indeed, that was quite a prodigious task. We used 50-year-old records from the internment office. We checked Social Security records, but the real key to it was the cooperative relationship between the Department of Justice and the community groups in the Japanese American communities. They were enormously supportive to the point that we would conduct training sessions for the members of these organizations to go out and do a lot of the legwork that had to be done, despite the fact that the Office of Redress Administration, which was within the Civil Rights Division, had 50 employees engaged. And believe me, that was no big bureaucratic, it was very serious work. And I think probably that effort is one of the greatest things that the Department of Justice through the Civil Rights Division ever done. They went out there. You're not obliged to come forward. You know, you want some other benefits, food stamps, whatever it is, you've got to come forward and ask. We're trying to reach out to you because we wronged you, and we feel that we ought to fulfill our obligation. Happily, it worked out, and I think that the program, was very successful. I'd like to just give you the final figures on what happened. There are so many interesting asides. Anybody still awake? Having been in the legislature, somebody comes up with a proposal and says, what's this going to cost? Well, they estimated that there were, of the 126,000 internees, maybe 60,000 were alive. But I don't know whether it's the good diet of the Japanese or whatever it is, but 82,500 of Japanese Americans received payments of $20,000 apiece. It wound up costing the federal government about $1.65 billion. Just a couple of, I think, interesting twists on this. There were some people who were told to go home, and they're not entitled to receive money. During the war, there were a great many Japanese Americans living in South America, mainly in Peru. And during the course of this program, there were about 2,000 of them sent to the United States. You know, the United States, our arms are open, come be with us. They said to the officials in Peru, send them up here, we'll put them in our internment camps. Now, they, under the statute, which was authorized by Congress, would not qualify because they had not been their original apprehension was not by reason of being in a restricted area of the West Coast. And during the war, they were denied residence, and after the Office of Redress Administration turned them down, 5 of the Latin American, Japanese American, sued the federal government saying, hey, wait a minute, we're just as entitled, we were in those terrible camps, I want my money. Well, as you know, in most litigation, they settled on the courthouse door and they agreed to pay $5,000 to Japanese Latin Americans to settle the class action, of whom there were 145. In addition to that, there was a situation where in the early stages and before the order of relocation and trying to carry out a program of voluntary relocation, a farmer from Oregon removed to Iowa and took his family there. And keeping in mind that there was an order, the Japanese American could not return to their home, they claimed that they were just as entitled to it because they'd been forced really to leave. But that didn't fall within the parameters of the statute. And so they sued, and the court held that it is in the spirit of the statute which authorized redress payments because the federal order had prohibited you from being into or returning to your ancestral home, which was a basic right, which was very interesting. In one of the dissents in the Korematsu case, Justice Murphy identified a prohibition for returning to one's ancestral home to be a constitutionally protected right. So they were awarded a certain amount. They were ordered $20,000. And in addition to that, in the Ishida case, a party had been born in the facility, an internment camp, mind you, and it was after the date of June 31st, 1942, which was a cutoff date. They claimed that they were entitled to be paid, and the Department of Justice rejected it, but the court determined on an appeal that they had been denied their right to return to their ancestral home and thereby were entitled to these funds. So in summation then, I think that the Civil Rights Act of 1988, which tried to provide some kind of an apology, some kind of an accommodation for those who had been so wrongly treated, accomplished a great deal, but the scars still remain with a great many, but I think it was a great lesson for us in America that we must be constantly vigilant to any threats to our security of the community. Let me just conclude, if I may, with something which I said to your predecessors in November of 1990. And I still believe it's relevant. We must be vigilant in the fight against growing mob who commit crimes of hatred, who tear deep holes in the fabric that binds our society together. Their acts subvert our nation's promise of liberty and equality, and they must be stopped. But that means more than just prosecuting the openly violent. That means stopping the sources and seeds of these senseless hate crimes. All those who snicker and laugh or simply ignore prejudice must bear the blame. It is not enough to condemn the extremes. We must work together to change the climate in America. We must make this a society that does not find prejudice funny or even tolerable. We must make this a society that is so inhospitable to bigotry that it cannot take root and spread, but rather withers and dies. Only then can we claim to have fulfilled our forefathers' dreams of liberty, justice, equality, and freedom for all Americans. Thank you. I hope I haven't taken too much time. I'd love to answer some questions.
What was the main reason for opposition to the initial redress legislation?
I'm sorry.
What was the main reason for opposition to the initial redress legislation?
The principle in the redress legislation that there was no basis for making a military decision which would justify the incarceration, removal incarceration of Japanese Americans. That the only, the two bases that DeWitt cited were none made of whole, they were made of whole cloth. There was no substance in them. And that they concluded that his decisions were really race-based, and they characterized him as a racist. So but what problem was, mind you, here you've got 9 members of the Supreme Court. They were just so taken in. They wouldn't even, for a minute, look at what the justification was for the order which General DeWitt issued. I mean, this is a time of war. We can't question that. And frankly, if you accept the idea that we're engaged in a war now, I would hope that the courts would not be nearly as timid with regard to reviewing. And one day, the question of use of drones, I think, is going to hit the court, and it involves citizens like you and I with regard to being potential targets of those. So our failures in the past ought to be a lesson to us, but we ought to be aware that we might have to revisit similar orders.
I think the question was, what was the opposition to the redress program? So initially, there was opposition to the redress program. So what were the arguments that we should not go into this? Cost or?
Well, of course, one was cost. The only member of the commission which looked into the incarceration was a Republican congressman from California. He said, I'm not buying this because I know my people in my district won't buy it, and therefore I'm voting against it. Interestingly enough, some Japanese Americans were offended to think that what you did to me can be compensated or made up for with a money payment. The other part of the Japanese psyche was, it was our misfortune and we'll take it. We don't need any kind of compensation. But I mean, anytime it seems to me you present legislation which would mean substantial expenditures, it's got a tough row to hoe. And the Japanese American community leaders recognize that. And that's why they launched such an aggressive campaign of mail, visiting with congressmen and other federal officials. It took a great deal of effort and privately raised money in order to overcome that opposition. And of course, nobody really knew where President Reagan would be, because he certainly was not very friendly toward civil rights issues and matters of that sort. I didn't mean to gloss over it, because the fellow who ran the program in the Justice Department said the secret to its success was the terrific cooperation of the Department of Justice and the community, communities who represented the Japanese American community. It was really grassroots. And in fact, he said it probably is the best example of a pure civil rights effort by the government, keeping in mind, we want to find you. And boy, they must have done some job, 2,250, when they expected about 60. Oh, and just another thing. They had done such a convincing job that after Reagan had provided no funding in 1990 for any payments, they went back, and every time they needed additional funding from the government, how much do you want? How much do you need? There was no resistance whatsoever. And when you consider that originally they thought they'd come in somewhere under $1 billion, and it wound up with $1.65 billion. I'm sorry, I misunderstood your question. Yes, ma'am.
In terms of the cost of the property that they left, was there any efforts by the government or by potentially like petitioners from the Japanese community to say, you know, this 25,000, this 20,000 isn't enough. We had substantial property that was worth this amount, so we should get that as well.
I'm glad you raised that, because I forgot to mention it. Before the redress legislation, there was legislation which provided funds in order to compensate Japanese Americans who lost property by reason of their internment, up to $100,000 per claimant. And that program went very smoothly, and it was very interesting. That program didn't have nearly the resistance that the proposal for internment based upon a denial of your human and civil rights. I don't know whether that's just business as usual. Let our officials think that the loss of property is more valuable than loss of your human rights. But it's a program that did. Thank you. I'm glad that you raised that. No other questions? Well, no, I have my second speech. Just a couple of points I made. If you're really interested in this subject, you probably know of the prize-winning novel Snow Falling on Cedars. It's a very interesting book regarding some internees in the state of Washington. It was written by David Guterson, and I recommend it to you for your attention. Much of what I discussed came out of a book, The Birth of an Activist, the Sachs Kitamishima story. She was one of the leading volunteers to organize the program to gain the attention of the federal government, and she was really the core leader of the letter writing and lobbying campaign. There's a lot of good stuff out there written on this subject. But I would just conclude with this. As a lawyer, as one who had the privilege of arguing a case in the Supreme Court, I'm always discouraged when our judiciary, which really in many cases is the lone or sole protector of human rights, took a dive on this whole matter of the internment program. I can understand, as they express very clearly in these dangerous times, we cannot question the decisions made by military officials. But it kind of reminds me of President Lyndon Johnson and Bush too. We'll talk to the generals in the field and figure out what to do. we've got to remain vigilant. We've got to demand that those who are charged with the heavy responsibility of running this government and protecting the rights of its citizens have got to be subject to very close scrutiny, and when they act to impair any of our rights, they should be very narrowly tailored so it does as little damage as possible to the rest of the community. I think it's a noble challenge. I envy you. You're on the verge of a whole new generation, I think, of jurisprudence. I think that the challenge is very much there. And again, I wish I were down there, not up here. Thank you very much.